Good afternoon, everyone. I'm Tony DeResta, and I'm here along with my partner, DeMorris Cohen, and we're privileged to be with you and talk with Michael Osteimer to discuss social media advertising and marketing. Michael is a senior attorney at the Federal Trade Commission in its Division of Advertising Practices, and he's been with the Commission for about 30 years now. He's one of the key thought leaders at the FTC involving social media and is involved not only in law enforcement investigations, but the development of guidance involving social media. We're so happy that he's with us once again. As a couple of years ago, DeMorris and I had the privilege of having a very productive conversation with him about the FTC's role in addressing consumer protection issues involving social media advertising and the regulations or guidance governing such marketing. I'm also pleased to announce that this webinar is the first in a series of webinars we're going to be doing, calling it Conversations That Matter, which on a monthly basis will feature interviews with senior governmental officials like Michael, thought leaders, general counsels, and policymakers concerning critical consumer protection issues. And I'm particularly thrilled that this series' inaugural event is with Michael today. Michael, thank you so much for joining us.
My pleasure.
So let's get started. Guess the first question on everybody's mind is the change of administration. We have a new president, a new administration. So I guess the threshold question on our minds is, will the new change of leadership at the FTC have an impact on your work at the Division of Advertising Practices? And if so, how?
Well, it's really too early to tell. Acting Chairwoman Slaughter just stepped into her new role. At some point soon, we will have one or more new commissioners. Certainly, if you read some of then Commissioner Slaughter's concurring and dissenting opinions, you'll see where she might want to do things differently. For example, in my case, Sunday Riley, she thought the commission should seek monetary remedies even when estimates are uncertain, comprehensively study the problem of fake reviews, analyze how reviews influence recommendation engines and algorithms, determine whether e-commerce marketplaces consistently enforce the removal of fake reviews or selectively enforce based on their own economic incentives, and uncover how fake reviews might contribute to the importation of unsafe or counterfeit goods from overseas. In a recent speech, the acting chairwoman said that she will continue to want to focus on pandemic-related issues, which has been a focus of my division, which will continue to be.
No, thank you, Michael. That's quite a lot to absorb.
Sure.
And I'll turn it over to DeMorris now to talk about this, or question you about the social media landscape.
Thank you, Tony, and it's a pleasure. Thank you, Michael. It's a great time to chat with you again. And so we chatted about the Biden administration and the change, and so we'll jump into social media, into social media landscape. And the first question I have, which is related to a few of the things you just mentioned, fake reviews, essentially developments in social media practices. So my question is, what new developments in technology or marketing practices are happening that are of interest to the or concern to the FTC?
While there is a lot of public concern about the role of platforms and algorithms in advertising, the Commission recently issued 6B orders to social media platforms. The orders ask about privacy issues and a wide range of digital advertising services. In the recent funding bill for the FTC, Congress asked us to complete a study on whether and how artificial intelligence may be used to identify, remove, or take other appropriate action to address online harms.
Perfect, thank you. That's helpful. It's a lot in that answer. And so I guess to simplify it, I would ask a follow-up question. So do we foresee an enforcement shift maybe in the commission, given the new administration and some of the concerns?
As I said in my initial answer, it's too early to tell.
Understood. So then how we'll jump to we'll stay with social media landscape, but we'll jump into, I guess, another focus within the landscape. And this may seem like a basic question, but I think it's important just for the listeners to hear.
Sure.
Does the FTC view social media advertising as being any different or subject to different rules than traditional advertising or marketing?
Social media and other online advertising is subject to the same rules as traditional advertising. The principles are all the same. Look at the Commission's enforcement policy statement addressing native advertising. It's based on numerous old cases involving deceptive formats and deceptive door openers. And our work on influencers is rooted in the same concepts we earlier applied to other endorsers.
Perfect. Thank you.
Sure.
And, on it, again, staying with social media landscape, just for one last question. Chopra stated last year that one goal of the FTC is developing requirements for technology platforms, Instagram, YouTube, TikTok come to mind, that facilitate or either directly or indirectly profit from influencer marketing. Where does this stand would be the first question.
Well, actually, listening to you talk just now reminded me that I should have given a disclosure that's really, really important that I didn't give at the beginning of our discussion, which is that I'm only speaking for myself. My views don't represent the views of the Federal Trade Commission, of Commissioner Chopra, or any other commissioner. They only represent my own views. As far as your question, platforms can play a role in addressing issues relating to influencer marketing, and some do a better job than others. However, we do face a number of challenges in enforcing platform accountability, including Section 230 of the CDA, the Communications Decency Act. Nevertheless, we will push forward where we can. We would like to work cooperatively with the platforms to have them take greater responsibility for clarifying the commercial nature of influencer posts. But if that fails, we are prepared to consider other options.
Understood, and thank you. And of course, we understand that your comments are yours. And Tony, with that, I'll actually turn it back over to you so we can chat actually about the revisions to the FTC's guides.
Thanks, DeMorris. Michael, as you can appreciate, I mean, when the guides first came out, almost a decade ago, it obviously...
Well, actually, Tony, sorry to interrupt you. They came out in like 1970.
I'm thinking about the changes. Good, you're making me feel young again, Michael. Thank you. But I know when social media marketing was on the rise a decade ago, or whatever time frame.
Yeah.
With COVID, I'm losing a sense of timing. But obviously, these guides had a substantial influence because it focused not only on the platforms, but on the speakers and the roles that endorsers, testimonialists, celebrities, experts had to play. So this is obviously on the mind of companies quite a bit. So what is the status of the revisions to the guides on testimonials and endorsements right now?
Well, every 10 years, the Commission reviews its various rules and guides. And last year in 2020, we started a review of the endorsement guides. We published a series of 22 questions in the Federal Register. For example, we asked about review gating, and we asked about what evidence supports or contradicts the assertion that consumers who use social media understand that influencers who promote products are generally doing so only because they are paid or given something by brand. We received 108 substantive comments. All are publicly posted on the website regulations.gov. And there's a docket ID if people want I could give out, or you can just search. We've been reviewing those comments and preparing recommendations on revising the guides. The Commission will decide what changes, if any, it wants to make, and its proposal will be published for another round of public comment before any changes are actually implemented. I mean, if we had 10 minutes, I'd be happy to run through some of the topics that were raised in the comments, but I think that would take too long. And so why don't we move on to your next question, if you'd like.
Sure. Any sense of the timing? When do you think we may get some kind of update or feedback?
I'm sorry, I don't have a timing answer.
No, I couldn't resist the question.
Sure.
next question. Commissioner Chopra made a statement that the FTC should focus on law-breaking advertisers rather than on the small influencers. Obviously, the website of the FTC makes clear that it does fall on the influencer to be familiar with the guides and the laws. But do you, looking in the crystal ball, do you foresee that the FTC is now going to be more focused on law-breaking advertisers as opposed to small influencers?
In this space, meaning endorsements and influencers, the Commission's focus has always been on advertisers. To date, we have not brought a case against an ordinary individual influencer. That isn't to say that a case might not be appropriate. In the staff guidance to which you're referring, we said that one example of when a case against an individual influencer would be appropriate is if an influencer ignores a staff warning letter. But generally, the focus has been and will continue to be on the advertisers themselves.
Got it. One question I had, it came up in a conversation a couple of weeks ago. I remember in the beginning of the Obama administration, it was one of the first large law enforcement actions, and the respondent was a major brand. And I remember at that time, the chairman made a comment that we're going to be focusing on major brands, and because of the fact that major brands have more public recognition, more trust from consumers, if you will, that there isn't, I don't want to say a higher expectation, but they're going to be looked at more closely. Is that still kind of the standard, that major brands or companies with higher public recognition maybe have more trust and influence over consumers, that they should be held to a stricter scrutiny standard, if you will?
I think all companies should be held to a stricter scrutiny standard. And I wouldn't necessarily focus on a major brand versus a minor brand. All companies should be transparent and telling the truth.
That's fair. Thank you so much. DeMorris, I'll turn it over to you now for conduct by tech company.
Sure. So conduct by tech companies, obviously tech companies have been the focus, we'd say, for the last 12 months at least, if not longer, but particularly a focus the last 12 months. Given this recent focus on the impact of large platforms on disseminating content that may be inaccurate or unfair, or, for instance, not advancing the public welfare or in the best interests of democratic values, is the FTC considering issuing any guidance for tech companies like Facebook or Twitter or others that not only impact the tech companies, but that could impact brands that use these tech companies to advertise?
Okay. Well, you mentioned advancing democratic values. That sounds like political speech, and we don't have any authority over that. The FTC's jurisdiction is limited to commerce. And within that domain, we have been reaching out to large internet platforms in a number of areas. It's obvious that many of these platforms could be doing a better job policing deceptive commercial activity. So in fact, we are considering the need for greater engagement.
Perfect, thank you. And as with Tony, I would assume there's no timing on this engagement, but it should be on the minds of the tech companies. That's
correct.
Perfect. Thank you, Michael. And so as a follow-up, in December of 2020, there was a Section 6B investigation, and the FTC indicated in that release that entities had 45 days to provide data on how they collect, use, and present personal information, their advertising and user engagement practices, and how their practices affect children and teens. Have these companies provided the requested information at this point?
I can't comment upon that.
Fair enough. And I guess the question ultimately what I want to get to is, what is the FTC looking to accomplish with this investigation?
Sure. Social media and video streaming services have become almost unavoidable in today's modern world, particularly as many Americans are working from home, socializing, and attending school online during the national pandemic. Despite their central role in our daily lives, the decisions that prominent online platforms make regarding consumers and consumer data remain opaque to consumers. The FTC's decision to conduct a Section 6B study to assess the privacy practices of social media and video streaming firms is just a first step toward getting much needed clarity. The FTC will decide on possible next steps after it receives and evaluates the information from the companies.
Thank you, Michael. And so sticking with this, obviously, the FTC is going to, as you said, investigate and I guess make a determination as to the data and what it's seeing. What should brands be doing or not doing regarding the privacy data, to the extent that you could answer that question?
That's a question that's beyond my area of expertise that I'm really not prepared to answer.
Understood. And then I guess I'll just
if you spoke to one of my colleagues in the Division of Privacy and Identity Protection, I'm sure they could tell you many things that brands should be doing as far as protecting their consumers' privacy and being transparent about the information that they're collecting. But it's not something I'm really prepared to answer.
Understood, and I appreciate that. And so then I'll just ask a quick follow-up. The priority seems to be on larger companies. Are we setting an example, or again, is this beyond kind of, I guess, where you're prepared to answer?
When you say setting an example, I'm not sure what you mean. This is information collection. These are not law enforcement investigations.
Understood. So then we'll kind of change topics then. We'll stay with platforms and social media, but we'll move to what we call our UGC, our user-generated content.
Sure.
Just I guess at a high level, what consumer protection issues are triggered with user-generated content?
Well, user-generated content that is commercial speech and attributable to an advertiser can influence consumer decision-making. Therefore, it should be truthful and non-misleading. Among other things, any claim communicated by such UGC must be substantiated. If it's advertising, consumers should recognize it as advertising. If there's a material connection between the user and the content generator that isn't obvious, it should be disclosed.
Thank you. And so speaking of disclosures, what concerns, if any, by a small market influencer who so happens to simply like a product, as it is like on Facebook or like on Instagram, which is independent from an influencer from a brand, or excuse me, independent from an influence from a brand? What are our concerns there with just a like, for instance?
Well, there's two different questions where there's just a like, but if someone endorses a product completely independently from a brand, then not only is it not the brand's responsibility, but there's nothing to disclose. That applies to everyone, a small-time influencer, a big-time influencer, an average consumer. I don't know if you remember from our last discussion, but back in 2017, we sent letters to 90 influencers and brands, and it turned out that a number of the endorsements we observed were truly organic, and there's not something that would be subject to an FTC investigation or enforcement action. An influencer was just talking about a brand they truly liked, and there was nothing to disclose. You asked about a simple like as opposed to another type of endorsement. And at least the last time we updated our commission staff guidance, we said it still is an open question to the extent that consumers find a simple like, nothing more on Facebook to be material. So I wouldn't be prepared to say that a simple like, if it was incentivized, is necessarily deceptive. But you were talking about people doing things without even having any connection whatsoever to a brand. So if somebody who has no connection whatsoever to a brand likes something, there's definitely no issue with that.
Understood. Appreciate that. And so we'll change gears here, and we'll go into law enforcement actions, and I'll turn it over to Tony to chat about that.
Thanks, DeMorris, and thank you, Michael, for being really transparent here on some of these questions. I want to ask you, what are some of the recent enforcement actions involving social media marketing that companies should pay particular attention to right now?
Well, one case, which was my investigation from last year, was against a company called Teamy Inc. and its owners. Teamy received a warning letter from FTC staff about its influencers not making adequate disclosures on Instagram. The influencers were making disclosures that wouldn't be seen without a viewer clicking on a link labeled more. TME adopted a policy saying that influencers should make disclosures above the more link, but they did not enforce the policy, and many influencers did not comply with it. FTC staff not only investigated the disclosure issue, but also TME's product efficacy claims made by its influencers and by the company itself on its website and in social media. We ended up bringing a case against the company, which agreed to a $15 million judgment that was partially suspended based upon ability to pay. So, I mean, that's so basically, one thing is that disclosures should be clear and conspicuous. On Instagram, they should be above the more link. It's not enough. It's not enough just to have a social media policy. It needs to be communicated. There needs to be training, and there needs to be enforcement of it.
Thank you. Question about, I guess, how do you feel about your successes in law enforcement actions? Obviously, companies that are compliant, which is a vast majority of them, we hope, pay close attention to the public announcements, the guidance, the press releases, the law enforcement actions. I guess what kind of lens, how should companies, when they look at all this content produced by the commission, how should they look at that? Is that something that needs to be baked into their compliance management programs? And do you feel that the staff of the commission's done an effective job in, I guess, instructing and educating companies about what your expectations are?
If you're asking about the effectiveness of education, we do think we have done a good job. I mean, we can do more. We have business education guidance documents, including the endorsement guides, frequently asked questions, and we have an email box, endorsements@ftc.gov, where we answer all questions from anyone to the extent possible about compliance with the endorsement guides. We also try to get the word out both with cases, with speeches, and with otherwise. We have a guidance document we prepared for influencers themselves. I mean, we have been very active in combating misleading endorsements, and not only suing companies, but also trying to educate the advertising industry, which follows our enforcement work closely, and using our partners, the NAD, the states, and through education, where I think we're magnifying our impact.
Michael, thank you for that. I just want to comment, as you were identifying all these different ways in which the FTC communicates and gets the message out, I just find it important for companies to hear that when they think about precedent, litigators tend to think, well, we're going to look at case law and so forth, but there is a big body of precedent that the FTC has, whether it's speeches, warning letters, law enforcement actions, guidance, questions. It's a big and important body of precedent. So I'm glad you set that forth, because I think that's important for our companies to hear about. Changing gears somewhat, big interest is made in the USA claims right now, and especially some recent enforcement activity concerning the marketing of the all or virtually all standard. Any updates or thoughts you have on made in the USA claims and how that standard is going to be applied?
Well, I'm not an expert on made in the USA issues. In fact, the different division, the enforcement division, takes the lead on investigating and bringing those cases. But I can tell you a little bit about what I do know. FTC staff is committed to helping businesses that create jobs in the United States promote the good work that they do here without deceiving consumers. We provide informal staff feedback on this topic to any business that seeks it, and we welcome questions or complaints via email at MUSA, as in made in the USA, MUSA at ftc.gov. So I answer emails at enforcements.ftc, and the made in the USA people do it at ftc.gov.
Great.
With that said, in appropriate situations, we do recommend enforcement actions. Last week, the FTC gave final approval to a consent order under which a superglue manufacturer will pay $1.2 million as total charges. It sold its product with misleading made in the USA labels, and I believe that that's a record amount for a made in the USA settlement. We also recently saw comment in an ongoing proposed rulemaking. The proposed rule incorporates the all of virtually all standard and applies to labels on products, including in mail order advertising. The proposed rule that's being considered would impose no new burdens on marketers already complying with the law, but would give the FTC civil penalty authority. The latest comment period closed, and I understand the staff is reviewing the comments received.
No, thank you. Let me ask you this. In terms of the relief that's sought in law enforcement actions, it's obvious that monetary relief, in addition to the injunctive relief, in addition to corrective action, is now one of the tools in your toolbox. What criteria is used by the Commission to determine whether something beyond injunctive relief or corrective action is warranted?
Well, I believe that monetary relief will be considered in almost every, if not every, investigation. I expect that monetary relief and consumer notice will be important factors going forward in every, if not almost every, investigation.
Thank you. Does the Commission anticipate creating any new requirements for advertisers or social media platforms that could impose penalties for civil liability, anything above what we've articulated so far?
Well, I can't speak for the Commission, but I can say that at least we, the staff, are considering what tools are available to us, including civil penalties. When challenging conduct, we examine whether it violates an existing rule. So we might be able to get civil penalties under that existing rule if it's covered by the conduct at issue. We are also considering conducting new rulemakings, such as the ongoing one involving made in the USA claims, and we're considering that for other areas. The Commission can also serve individual industry participants with Section 205 synopses, putting them on notice as to illegal conduct and subjecting them to civil penalties for engaging in such conduct. And we're considering doing that more than we have in the past.
Interesting. Thank you. Thank you for sharing that, Michael. Damaris, I'll turn it over to you for a focus on brands right now.
Sure. Thank you, Tony. And so, Michael, we chatted earlier about, the focus usually being on brands historically, and obviously we have influencers in the mix and guidance that's issued to the influencers. And we just spoke about investigations and relief. So I guess a question that I'm asked routinely is how will targets of future investigations be evaluated? For instance, what are the criteria that the FTC is looking at in determining whether to issue a warning letter or to commence an investigation?
There are numerous factors in evaluating cases. One important factor is the injury to consumers. For example, does the matter involve health or safety, or what is the economic injury? Another factor is the egregiousness of the conduct. What was the dissemination of the deceptive ads or potentially deceptive ads? We also often investigate emerging practices that are new in industry. Although our first step in such matters might be business guidance or a warning letter rather than a full-blown investigation and enforcement action. Although we sometimes start by bringing a case. We also consider whether bringing a case would send a message that we think needs to be communicated to other businesses or to the public.
Perfect, thank you. And I'm going to change course just slightly here. So we chatted about fake reviews and the concern with fake reviews. So we have the Consumer Review Fairness Act, and in relation to that, can brands, for instance, censor less favorable reviews?
Brands should not censor less favorable reviews. We brought at least 10 cases involving the Consumer Review Fairness Act violations, which involves form contracts, and we will continue to enforce that act. We also care about other forms of review suppression. In one case, we challenged as unfair threats of physical harm to consumers who posted negative reviews. We also recently issued a closing letter to a company called Yotpo, which provides review management services. We were concerned that Yotpo's star rating and sentiment filters provided its clients with the means to instrumentalities to easily and deceptively suppress negative product reviews on their websites, and to mislead consumers that the reviews displayed accurately reflected the views of all purchasers who submitted reviews. Among other things, Yotpo implemented prominent guidance to its clients on their need to promptly post reviews, including negative reviews, and it also began automatically posting negative reviews that had not been promptly acted upon by its clients.
Perfect, thank you. And so just a follow-up question, given the concern, should brands foresee stricter enforcement of censoring of less favorable reviews, particularly in light of the Sunday Ridley action?
Well, yes, companies should expect that we will try to strictly enforce censoring of reviews, that reviews should not be posted or should not be removed simply because they are negative. I don't really know how that has anything to do with Sunday Riley. Sunday Riley, which actually was one of my cases, involved a CEO writing fake reviews herself for her products, and for her asking her and her officers and management asking other company employees to write fake reviews. So, I mean, that was a really bad practice, but it doesn't really have to do with censoring reviews as opposed to posting fake reviews.
Agreed. No, and so my question was just more so just the field of reviews, because reviews are something that is clearly a hot topic. You know, it is something that's used by brands to really impact consumer spending. And so we have, you have two kind of areas here. We have the less favorable censorship issue, as well as the fake review issue. And so that was really the question is, should brands should really be focused on reviews, and it should not be something that is just placed on the website, for instance, allowing for consumers to submit fake reviews, for instance, if you have, we ran into this issue before in the past, or, having actual contracts where fake reviews are entered. And so that's really more a question, is just kind of to put brands on notice that this is a concern.
Brands soliciting fake reviews or buying fake reviews is a problem. Brands blocking negative reviews or discouraging negative reviews is a problem. Both are problematic. Consumers should be able to trust and rely upon reviews.
Agreed. And so from here, we'll turn to warning letters, and I'll turn that over to Tony.
Thanks, Demorest. Yeah, let's take the word reviews instead of a noun. Let's make it a verb. And reviewing warning letters. We've been talking a lot about warning letters. In terms of when companies review or evaluate warning letters, how should they be interpreted? What's the value of them, quite frankly, to educate? Obviously, you're sending a message to the recipient about some potentially illegal or wrongful conduct. But, I'm assuming that's also to send a message to others in the industry or other stakeholders or players as well.
Well, warning letters allow us to have a much larger impact with our limited resources. We can get many companies to come into compliance once we've warned them, and we only have to proceed against the few who choose not to comply. Also, as you said, announcing a warning letter project gets the attention of others engaged in similar conduct and of the public. One area where we've recently used warning letters successfully is with the COVID-19 health claims. And I mean, I think regardless of the topic, I don't think there's any ambiguity in how warning letter recipients should interpret them. They should seriously consider changing their conduct if they don't want to be the target of an FTC investigation.
Oh, thank you. DeMorris, I'll turn it back to you on content, problematic content on the platforms.
Sure. Thank you, Tony. So, Michael, we chatted earlier about fake news and the concern with disinformation on social media. And obviously, you made the comment on political speech. But in the same vein as deception, dishonesty, failure to disclose, how is the FTC approaching abusive content, fake news, and misinformation?
Well, as we talked about before, the FTC is limited to commercial speech. So if disinformation isn't aimed at selling a product or service, we don't have jurisdiction. That doesn't apply just to political speech. It also applies to all sorts of other speech that may be disinformation, such as vaccine disinformation.
Understood. And so let's change course a little bit to influencers. And, we spoke about brands at length. And so let's chat about influencers and the issues that we may see in social media with influencers. And so obviously we chatted already about the disclosure guides that went out for influencers to provide some guidance on how they should be disclosing their material connections in social media. And I guess the first question, is there any thought on further revisions to the guidance for influencers?
Well, the guidance for influencers, Disclosures 101 for social media influencers, was a brand new document we issued in November of 2019. And it didn't say anything new, but it was written to and for influencers themselves as opposed to for lawyers or for brands. And as part of our review of the endorsement guides, staff received numerous comments and questions. Depending on how the commission changes the endorsement guides, staff may need to update our guidance to influencers and our other business guidance. But we'll have to see how the endorsement guides change. In addition, there may be issues that the commission doesn't address in the guides that staff chooses to address in business guidance. There may be some minutia or detail that just doesn't belong in a commission guide document that we can address in staff guidance, business guidance.
Thank you. Understood. So I guess on that topic then, what disclosure issues are we seeing or it's giving the FTC concern from influencers?
Well, I mean, some influencers are making deceptive claims. And as I said, in the teaming matter, we had allegations or complaint based upon deceptive claims by influencers. And there are influencers who are not disclosing or not adequately disclosing a material connection to a brand that has either paid them or otherwise incentivized them, which should be clearly and conspicuously disclosed.
Perfect. And then last follow-up question on influencer disclosures. Should the brands be paying attention to their influencers, and what are the responsibilities of the brands as it relates to influencers and appropriate disclosures?
Yes, brands should be paying attention to their influencers. They should be giving guidance to their They should have guidance to their influencers on what they should and should not be saying. They should be having, in terms of both not making deceptive claims and in terms of how and where and when to make disclosures of material connections in various situations. Not only should they be training and giving guidance, they should also be monitoring the influencers. If they are reviewing or pre-approving posts before they are actually posted, they should review them for compliance with making disclosures and with the company's disclosure policies. And if they're not pre-approving posts, then they should review the posts after they are posted. And they should also take action when they see that an influencer is engaging in problematic behavior.
Perfect, thank you. And so we chatted about policies, and I think this is a good time to really transition to social media policies and what brands should be doing in that space related to implementing social media policies and going about enforcing their policies. And so Tony, I'll turn it over to you.
I'll just ask I guess the threshold question. I know the staff, the commission has spent a lot of time focusing on companies setting up appropriate social media policies. That's still something of interest to the commission, Michael. And if so, do you have any advice as to really what the essential ingredients or factors are for social media policies?
Social media policies are very important, but it's not just the social media policy that matters, but the training and the guidance. It's fine to tell influencers to tell the truth and not violate the law, but that's not enough. What's more important is telling them what they can and can't say about a product in terms of claims, and giving them guidance, as I said to Damaris, about when and how to disclose material connections in various scenarios. And a social media policy should address everyone else with a material connection, not just influencers. Everyone else with a material connection who might endorse their company's products, including employees and potentially consumers. As I said to Damaris, a social media policy should be implemented with appropriate monitoring, and if posts should be reviewed, whether it's before or after they're made. And I mean, we don't expect that an employer could necessarily monitor, actually, we don't expect that an employer could monitor every post by its employees in all forms of social media, as you may well know yourself. But if a company becomes aware of non-compliant posts, it should take appropriate action. Also, if a company is running a promotion, for example, that rewards consumers for endorsements, it shouldn't reward consumers who don't make adequate disclosures.
Perfect.
Thanks. Damaris, any follow-up thoughts or questions?
Not on social media policies. I think we've hammered that home. I know on the last call we had Michael, we chatted about social media policies and ingredients. A couple of things that came to mind were examples. A good social media policy would have examples that educate their, again, employees, influencers, vendors, and I think it's important for brands to understand that this policy really does apply to anyone that not only has the authority to speak on behalf of the company, but also employees or others who may have the ability to influence consumer spending. And I think that that's a big focus, and that's something we chatted about last time in depth with Michael. And so I'm good on social media policies, but related to social media, I did want to chat about something that we have not spoken about before, but that we're seeing all the time in social media. And that is, I guess, my baby, which are sweepstakes and promotions. You can't go on Instagram nowadays or Facebook without seeing a giveaway or sweepstakes of some kind. And so I guess the first question I'll ask is this a concern for the FTC?
Well, I mean, are sweepstakes a concern, or
the practices behind the sweepstakes? The structuring of them, different things like that you'll see in social media.
Well, I mean, there are many issues relating to how companies should handle their sweepstakes and their contests. Those are mostly regulated at the local level.
Of course.
The FTC has been concerned in the past, though, when entry in a sweepstakes or a contest is used to incentivize product endorsements. We addressed that several years ago, both in a closing letter to Kohan and in the staff guidance. If an incentive could matter to viewers of any resulting endorsements, then the incentives should be disclosed. One way to have a disclosure would be for the company offering the sweepstakes or contest to require that posts start with something like #brand sweepstakes, like, for example, Dorito sweepstakes.
Good, thank you. I appreciate it. And my question there is just because you see a lot of them, and I think a lot of times brands may not realize that not only do we have the state issues related to sweepstakes and possible registration and things like that, but it is a concern from a deception as well as a disclosure standpoint. And so I'm glad you'd addressed that for us. And Tony, I think we have about 15 minutes left, and so a good topic next to turn back to is investigations.
Sure, thanks, DeMorris. Michael, let me ask you this. Obviously, as companies look at compliance, the issue that bubbles up is risk management. And one of the questions I hear constantly is what does it take for a company to get a CID or a subpoena from the FTC? What are the factors that you look to in making a decision when to open up an investigation? What do you look for?
Well, there's two different issues. One is, where do we get our investigations from? And two is, what are the factors that we look for in deciding to actually make this a priority over another matter? As far as those are two different questions. The second question I already addressed before. I talked about the factors on how we pick one matter versus another matter in terms of egregiousness, consumer injury, economic and health injury. I mean, I went through those factors before. In terms of where do we get our investigations, I mean, we monitor consumer complaints. We get complaints from consumer groups, from competitors, and from whistleblowers. Right now, I have a couple of investigations just started from whistleblowers. Staff does its own monitoring. We conduct sweeps in some areas. We've also started investigations in response to congressional inquiries and to news stories. I've had multiple cases that started from news stories. And those are some of the sources.
Oh, thank you, Michael. Thinking about risk management, DeMorris, I know you had a question about the NAD.
Absolutely. So we chatted about the source of investigations and what role does the NAD or other agencies like that, self-regulatory agencies, play in investigations?
Well, the FTC is too small to simply depend upon ourselves. We have to draw on resources outside of our agency in terms of industry self-regulation. The FTC highly values the role of BBB National Programs, National Advertising Division as a self-regulatory body, and the other organizations within BBB National Programs. NAD attorneys are skilled and knowledgeable, and they issue decisions only after reviewing the record, conducting analysis, and giving parties the opportunity to be heard. For that reason, when NAD refers a case to us, we take it very seriously. It goes to the top of the pile. The FTC receives referrals when an advertiser refuses to comply with a self-regulatory decision. We receive and review the whole case file. The most common outcome of a referral is that an advertiser comes into voluntary compliance with the NAD's decision, but referrals have also resulted in investigations and in law enforcement actions.
Perfect.
Thank you, Michael.
Go ahead, Tony.
Go ahead, DeMorris.
No, I was going to say, I think go ahead,
well,
Michael, sorry.
I was just going to throw in that we actually respond to all NAD referrals, and you can actually find them on the FTC website with letters back to NAD.
Michael, talking about partners that the FTC has, what about law enforcement sweeps? Is this, I don't want to call it a trend, but is the staff or the commission still going to be engaging with other law enforcement partners like state attorneys general, but in advertising matters, or are sweeps involving issues or topics outside of the Division of Bad Practices?
We are currently working with state AGs on a number of matters, and we will continue to do so in the future, both in advertising and other matters. We value our partnership with our state law enforcement partners.
Got it. Thank you. I think we're about to close. DeMorris, can you think of any other final questions before we conclude this very, very useful webinar?
No final questions on my end. I appreciate it, Michael. I think maybe some takeaways or high kind of omnibus thoughts would be the good for some of the brands. because obviously we can't answer everyone's question, but let's see if we could get takeaways and go from there.
I mean, I could talk for a long time on that, but the bottom line is tell the truth, don't exaggerate, and be transparent.
Fair enough.
Fair enough. It's so simple. Well, Michael, thank you obviously so much. You gave us a lot to absorb and marinate. Pardon the metaphor, but it's close to the dinner hour, so we need to be creative in our thinking right now. But this has really been outstanding once again, and we thank you for your time and your insights and your assistance. We really appreciate it. And as I said at the beginning, I'm really excited about getting this Conversations That Matter series up and running. And it's really special to have you as our first guest. Thank you so much.
I'm honored. Thank you.
So this ends this session right now. I wish you all a good post Valentine's Day for everyone who joined in. If you have any questions, please send them to Audra or to Demoris and me, or to Michael through some of the emails and the sites that he identified. In the meantime, stay compliant, and we wish you all well and stay healthy. So long, everyone.